The United States Supreme Court just issued a very important order in a case which challenges a state's ban on so-called assault weapons and also the state's ban on magazines that hold more than 10 rounds. So we need to break down what is now happening with this critical order. Now, really quick before we jump in this video, I want to ask you guys for a favor. Looking at some of my analytics, about 60% of all my viewers are actually not subscribed to the channel. So if you like this content, please consider subscribing. And then also for those of you who maybe are subscribed, if you could click the notification bell, a lot of people aren't aware that there's a bell icon. If you click that bell and turn on all notifications, it actually ensures that YouTube will send you these videos once I post them. But regardless, thank you guys so much for all of your support. As I mentioned in the intro, in this video, we're going to be talking about a very important order that was just issued by the Supreme Court. And this is in a case which is a challenge to a state's ban on so-called assault weapons and their magazine ban as well. The case we're going to be talking about in this video is Gray versus Jennings, and it deals with a challenge to the state of Delaware's comprehensive ban on rifles and magazines. This issue recently made its way to the United States Supreme Court. However, initially the state of Delaware notified the Supreme Court that they would not respond to the petition, that they waived their response, and that they were simply going to let this go to conference. And they believed at that time that maybe the Supreme Court would just simply conference this and then ultimately denied review to this issue after conference. However, the Supreme Court just issued an order and they have now requested, essentially demanding, that the state of Delaware file a response to this petition. This signals that the United States Supreme Court is very interested in this case and these issues that are presented in this petition. Now, this case involves the issue surrounding the state of Delaware and their ban on so-called assault weapons. The ban here in Delaware is similar to other states like California, which have a list of makes and models that they expressly ban, similar to how California has the Roberti Roos list. And then also on top of all of that, similar to California, the state of Delaware bans specific firearms based on their characteristics. So for example, an AR-15, which is a semi-automatic centerfire rifle, if it has offending features like a collapsible stock, a flash hider, a pistol grip, a forward pistol grip, any of those characteristics can then make it a so-called assault weapon, and it's banned in the state of Delaware. Delaware has also banned the most common and standard size firearms ammunition magazines. Simply any magazines that hold more than 17 rounds are banned in the state of Delaware. In response to this Delaware law, multiple cases were filed challenging the state ban, the various aspects, the rifle ban and the magazine ban. And then multiple cases were consolidated in a federal district court and then reviewed by the district court. In this case, the plaintiffs sought a preliminary injunction, which many of you know is a way to temporarily halt or block this type of restriction. On March 27, 2023, the district court entered an order, and in that decision, they refused to preliminary enjoin either the challenged bans. Neither did they want to halt the rifle ban or the magazine ban. The district court found that both the firearms and ammunition bans, these types of items are protected by the Second Amendment because they are arms within the meaning of the Second Amendment, and that they are clearly in common use for lawful purposes, including self-defense. Now, as a result of that finding there that these are clearly arms protected by the Second Amendment, that should essentially led to a preliminary injunction. However, the district court here found a way to justify these bans by looking at some of the aspects, looking at the historical context, looking at some of the evidence. And here the district court in Delaware, the federal court, wanted to use what is known as the more nuanced approach. They found that since these types of items are a drastic change in technology and that they potentially increase the harm to the public at large, according to the court, that requires a more nuanced approach and a broader historical analysis. And based on that, the judge here justified this ban. Also in this order, the district court judge found that the preliminary injunction factors were not met by the plaintiffs, and they found that primarily the constitutional violation here, the restriction on the constitutional right, did not lead to an irreparable harm. So they found that the restriction on your right to keep and bear arms, your restrictions on your ability to have these rifles or magazines did not cause enough irreparable harm. In response to this, the plaintiffs then appealed this up to the Third Circuit, and they wanted the Third Circuit to reverse that decision. However, on review, the Third Circuit sided with the state of Delaware. In this ruling, the Third Circuit took a very interesting approach. Instead of looking at the constitutional aspects, they focused primarily on the factors for a preliminary injunction. Ultimately, they found that the irreparable harm aspect, the factor for a preliminary injunction, was not met by the plaintiffs. The panel primarily based its holding on the conclusion that the challengers failed to demonstrate irreparable harm. The Third Circuit found that some of the constitutional harms are irreparable, but it insisted that those precedents all fell within an exception to our rule, and they presumed that the First Amendment harms are in fact irreparable. Now, what this led to was a distinction between the First Amendment and the Second Amendment. Essentially, the Third Circuit took the position that the First Amendment restrictions, those can cause an irreparable harm. However, when it comes to the Second Amendment and restrictions on the Second Amendment, those do not automatically create an irreparable harm. Once again, you had a circuit court decide to treat the Second Amendment as a second-class right. Now, this decision here and the petition now up for the Supreme Court review really deals with the standards for a preliminary injunction and whether or not restrictions on the Second Amendment and your right to keep and bear arms actually creates an automatic irreparable harm like other constitutional rights. Some circuit courts have stated that yes, it does, while you had the Third Circuit here say that no, it does not. And this dispute has now led the plaintiffs to seek Supreme Court review, and they have filed a petition to the Supreme Court. Now, the question presented to the Supreme Court on review is whether the infringement of the Second Amendment rights constitutes per se irreparable injury. The plaintiffs argue in their petition that the Circuit Court of Appeals have split over the question presented, with two circuit courts holding that the infringement of Second Amendment rights necessarily inflicts a harm that is irreparable, and the Third Circuit, through the panel's decision below, holding that the deprivation of Second Amendment freedoms does not inevitably amount to irreparable injury. They went on to state in the petition that the Third Circuit declined to enjoin Delaware's bans on common firearms and magazines, which the state dubs assault weapons and large capacity magazines, without even inquiring into whether those bans are likely unconstitutional based on petitioners' failure to establish an irreparable harm other than the loss of their Second Amendment rights. That refusal to treat the harm inflicted by the loss of Second Amendment rights as per se irreparable squarely conflicts with the decisions of the 7th and 9th Circuits, which have held that the irreparability analysis does not change where the constitutional violation at issue is a Second Amendment violation. And then they state that no amount of money could actually compensate a plaintiff for the loss of their constitutional right to keep and bear arms, and that this clearly is an irreparable harm that should have been recognized by the Third Circuit. They also state that the brevity of this court's decision on this subject has led to confusion and now direct conflict in the courts of appeals over the principles and nature and scope need the Supreme Court to finally step in once again. They conclude by saying that this court should grant the cert and clarify that the loss of Second Amendment freedoms clearly and necessarily constitutes an irreparable injury. Now that this case is in front of the Supreme Court, we were waiting to see maybe how the state of Delaware would respond, but ultimately, like I mentioned, they decided to not file a response. The state decided to actually waive that, and this was set to go to conference on November 8th. But then we got a request from the Supreme Court and we got an order from the court. The Supreme Court has now issued an order and has requested that the state of Delaware actually file a response to this petition, and that is due by November 27th. That means that the Supreme Court has taken enough interest in this case and this issue that they are demanding that the state of Delaware actually respond to this petition. This is now the second time in just a few weeks that we've seen the Supreme Court actually show an interest in a rifle magazine ban case. The first one was the Snopes Maryland rifle ban. There, the Supreme Court actually signaled that they wanted to hold conference on that issue before the end of this year. And now you have the Supreme Court once again stepping in, requesting additional arguments, in this case dealing with the state of Delaware's ban on rifle magazines. Again, keep in mind that this Delaware case is a little bit different because it primarily would deal with whether bans on rifles and magazines creates a per se irreparable harm when you're looking at preliminary injunctions. But this decision here, if you had the Supreme Court step in and issue an order that was favorable to Pro 2A side, inherently there would be language in here that would be very critical for future 2A cases, future requests for preliminary injunctions. And again, it would impact a ton of cases, but it would still be limited to the factors for a preliminary injunction, but it would set the standard that any type of violation or restriction on 2A rights is a per se irreparable harm to meet those factors. So I want to make you guys aware of this very important development in a rifle magazine ban case. The Supreme Court has now shown interest in this case, and now we will wait to see the Delaware response to this petition. So if we get any more information, if anything else develops, I will let you guys know. Also, if you like this video and you'd like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of 2A news. So as always, thank you all for watching. Don't forget to like and subscribe, and never forget this nation was built by armed scholars, and this nation will be maintained by armed scholars.